coming. This is the first in a series of presentations we've asked Chris to do for us. So he's great and he's pretty informal. I think he takes questions as you have them, but we also allotted time at the end to ask questions. So feel free to do that. I'm Mary Ann with RMDSA, Meg with RMDSA. Gilby used to be with RMDSA, but he still comes in. And I'm going to let Chris tell you about himself.
Thank you.
Hi. Are we good out in Fort Collins? Oh, I'm sorry, Grand Junction. Grand Junction. Yeah, everywhere. My name's Chris Brock. I'm managing attorney for CCDC Probate Power. CCDC is the Colorado Cross Disability Coalition. I am a 2014 grad of CU Law School and 2009 grad of Miami University in Ohio, and that's where, excuse me, that's where I'm originally from, is Ohio. I moved out to Colorado about 5 years ago. And so a couple things before we begin. One, as Mary Ann said, I'm pretty informal. If you have a question, just raise your hand and you can go ahead and ask it. And number two is that if you have a question and I don't know the answer, I'm just going to say, I don't know, but I'll find out. A lot of attorneys are afraid to say, I don't know, afraid to not know the answer. But I think it's important to, as an attorney, to let you know what I do know and what I don't know. If I don't know the answer, I'll let you know that, and then I'll find out, and we'll talk about it. Okay, so let's begin. So let's start at the beginning, which is what is a guardianship and what is a conservatorship. A guardianship is a relationship created by the court in which a guardian is authorized to make some or all of the important decisions for a ward that affect the ward's education, health, custody, personal relationships, basically any important decision for that ward. On the other hand, a conservatorship is a relationship created by the court in which a conservator is authorized to take title or manage the property for a protected person. Before a court appoints a guardian or a conservatorship, the person who petitions the court is known as the petitioner. They file paperwork with the court to have somebody appointed for what's known as the respondent. The petitioner must have an interest in the respondent, and is typically the person who wants to be appointed. Typically, the petitioner becomes the guardian or the conservator. Now, the respondent is a person who allegedly is incapacitated and needs some sort of protection, and that's the person that eventually, after the appointment, will become the ward or the protected person. We'll be using these definitions later on, so it's important for everybody to know who is who in the relationship. There's also people called interested persons. These are individuals that are interested in the individual's welfare that are required to be named in a petition, such as the respondent's spouse, adult children, and parents, caregivers, which include treating physicians, legal representatives, persons nominated by the respondent, any person alleged to have had primary care and custody of a minor 60 days before filing of the petition, each living parent or adult of nearest kinship, any person appointed by a parent of a minor, or any currently acting grantor or conservator. So these people have to be named in the petition so that later on, when the court has a hearing, they get notice of the hearing and they can appear at the hearing to either protest the appointment or be a witness if they want to be. Now, when is a guardian or conservator necessary? This is when the adult is deemed incapacitated and she or he had not executed valid legal documents, i.e. power of attorney, before becoming incapacitated. So if you have normally between two adults who have capacity, parent, child, say the child's 20, the adult's 40. If the child wants her parent to be her medical power of attorney, she can sign away, they can fill out a medical power of attorney and creates that relationship. But for that relationship to take effect, the person who gives away their rights has to have capacity. A guardianship is when the person is incapacitated. So for a person who has, and when we say incapacity, it means a person who is impaired by intoxicant, a mental illness or deficiency, or by a physical illness or disability to the extent that their decision making is impossible. So who can serve as a guardian or conservator? Basically just about anybody. Any person that's 21 or older. They can even live out of state. Usually it's a family member, a parent, or a sibling, professional fiduciaries, volunteers, public administrators, even the Department of Human Services in certain counties. Anyone that the court sees fit. Someone like Uncle Buck, maybe not so much. If you know that movie, it's an old movie. The nominated guardian or conservator has to submit to the court's review, and this is an important point here at the bottom, is that often some people think a long-term care facility, somebody there that works there, can be a guardian. But unless they're related by blood, marriage, or adoption, the owner, or operator, or an employee of a long-term care facility may not be appointed as a guardian.
Would that be creating a conflict of interest?
Basically, yeah. It's just in the statute, it just causes issues, basically. Now, there are a few different types of guardianships based on the ward's needs and capacity and ability to make decisions. There's a limited guardianship, and this restricts the guardian's authority to certain specified matters. Maybe as the guardian, you only need to help your ward with medical decision making, or it has to do with education or activities or personal relationships. It's most typical for the court to grant a limited guardianship, such as one of these. There's also an unlimited guardianship, and this is when the guardian has basically total decision making over the ward. In such case, a petitioner will have to explain to the court why an unlimited guardianship is necessary. The courts are quite, I wouldn't say suspicious, but they want to make sure the ward's rights are protected. And a guardianship is taking away the ward's rights. And so awarding an unlimited guardianship, you really need to explain why that is necessary for the best interests of the ward. There's also emergency guardianships, and this is when the guardian will be appointed if there's an imminent threat to the respondent that could cause the respondent's health, safety, or welfare to be in danger. Now, this is probably the most important slide that I've put in here. It's about maximizing personal autonomy. There are numerous provisions in the statutes that require the court visitor, we'll talk about that in a second, the petitioner and the guardian or conservator to consider the least restrictive means available to protect the individual, taking into account the use of reasonably available technology. So courts, like I said, are very suspicious, that's the wrong word, very careful about giving away the ward's rights. And whenever feasible, they only grant to the guardian what is necessary by the ward's limitations and needs. So the guardian or conservator shall encourage the ward and or protected person to participate in decisions and consider their personal values and express their feelings about the decisions. And as an organization, as an attorney, organization CCDC, this is the way we feel. As somebody with a disability, we feel very strongly that people with disabilities, even those who are incapacitated, they do have some decision-making capabilities, whether it's what they're wearing that day or what activities they want to do that afternoon. There's always, some decision-making that they can probably make that you should probably try to talk to them about. So we believe that somebody with disabilities, no matter, even if they have trouble speaking, have trouble with cognitive issues, if you talk to them enough and figure out their personal values and feelings about stuff, there's a way to figure out how they feel about certain decisions. Now, here's the appointment process. In the district court of the county in which the respondent lives, you file the following forms. Now, Denver has its own separate probate court, but every other county, they just have the probate court is mixed with the criminal and civil, or with the civil. So in the county in which the respondent lives, you have to file 5 forms. One is a petition for the appointment, and this is where you put all the contact information, living arrangements, the authority requested, the respondent's assets and income, the alleged capacity. Along with you have a physician's letter describing the impairment, cognitive issues, any development issues. You also attach your power of attorney if you do so have one. Second is the acceptance of offense. And this is the guardian has to accept the guardianship and the responsibility. And here you disclose any court involvement you could have, whether you've been convicted of a crime, any civil judgments against you, any restraining orders against you, anything like that, you have to disclose to the court. In the acceptance of offense, you also need to provide a name-based criminal background check, a current credit report, and copy of your driver's license. Now, the credit report and the criminal history check, those are not required if you are the parent of the respondent and you live with the respondent. That's just for other people. Third is an irrevocable power of attorney, but that is only if the nominated guardian or conservator lives out of state. In this case, you need to fill that out so that the clerk of court can be the agent of service. Fourth is the proposed order of appointment. This is just the proposed court order you write out that you propose what appropriate restrictions and authority you think the court should grant you. And then fifth are the proposed letters of guardianship or conservator. These indicate whether the appointment has been made and any limitations, and these serve as proof of your legal authority. So often, these are what you carry around with you to show that, hey, I'm the guardian. After you have filed those paperworks, the hearing date is set, and then the court will have a court visitor come and visit your house, personally interview the respondent, the proposed guardian or conservator, petitioner. Often will interview the physician and provide the court with a report summarizing his or her recommendations in terms of how limited or unlimited the guardianship should be. There are many requirements for a court visitor, so including advising the respondent of his or her rights and the nature of the proceedings. And unfortunately, the petitioner is responsible for paying for the court visitor. This varies by county. Sometimes it's hourly, sometimes it's a flat fee. While this is going on, you must provide due process, which means you must provide notice. Notice of the hearing, you must provide notice of the hearing date to the interested people and to the ward, or I'm sorry, to the respondent. In the notice of hearing, the respondent has to include the statement that the respondent must be present unless excused by the court, informing the respondent of his or her rights at the hearing, and a description of the hearing and appointment process. The respondent must be personally served, which is a legal term, and you must be served with the papers through process of service, and serve the proposed order, petition, and notice of hearing. And then the interested persons, who are spouse, physician, they must be served either via mail or e-service, the petition and notice of hearing. The hearing, which is typically about 6 to 8 weeks after you filed the petition, the respondent has certain rights during the hearing. He or she has a right to counsel. They have a right to a professional evaluation. They have a right to either have the proceedings either closed or open. They have the opportunity to be heard, to examine witnesses, and to examine documents. And a minor that's 12 or older may consent or object to proposed appointments. During the hearing, there's typically an opening statement and or a summary from the attorney. If it's uncontested, there might be witnesses called, might not be. If it's a contested hearing, most likely witnesses will be called and examined. The court normally uses the guiding principle of least restrictive means and best interest standards. So least restrictive means in order for the ward to still have some of his or her rights, and the best interest of the ward. During the hearing, the court must find a few findings. During a guardianship hearing, must find that the respondent is incapacitated and that the respondent's needs cannot be met by least restrictive means, including the use of appropriate and reasonably available technology. For conservatorship, the respondent is unable to manage property and or his or her business affairs because he or she cannot evaluate or receive information or make communications. And the respondent has property that will be wasted or dissipated unless the management is provided and or money is needed for the respondent and his or her dependents. Now for the guardianship, after the appointment is made, within 30 days, the guardian must send the ward and interested persons a copy of the order of the appointment. And then within 60 days, they must file his or her initial guardian's report with the court, and also send this to the ward and interested persons. In this, they must discuss the condition of the ward, the guardian's plan for the care of the ward, and an accounting of the ward's assets and income. And once after that, every year, they must file with the court and send to the ward and interested persons current medical, physical and social condition, living arrangements, the services provided to the ward, how adequacy of care is going, summary of the guardian's visits, ward's participation in decision making, if the current care plan is right for the ward in the ward's best interest, and any recommended or requested changes from the court. The guardian's duties and powers. While guardian, unless limited by the court, the guardian basically assumes the duties and powers of a parent. So it's required to see to the basic personal needs of the ward, which means food, clothing, shelter, and the ward's money and personal effects are reasonably cared for and used. Now, on behalf of the ward, the guardian can apply for public benefits, enforce contracts, take custody of the ward, consent to medical care and or services, and can even seek court approval for divorce and or separation. There's still a few limits. Even in an unlimited guardianship, a guardian may not consent to mental illness or substance abuse treatment against the ward's will, and cannot revoke medical power of attorney without court approval. So medical power of attorney, that agent has authority over the guardian in terms of medical decision making. Now, for a conservatorship, within 30 days of the appointment, it must send the protected person and interested persons a copy of the order of appointment, and then within 90 days, file a financial plan and inventory with the court, and send this to the protected person and interested persons. This will include the needs of the protected persons and the protected person's assets, income, and expenses. And then, like the guardian, file annual reports with the court, which detail the assets, receipts, disbursements, distributions, and then services, and then any recommended changes. Now, a conservator, their duties and powers are similar to that of a trustee for a trust, which means they have the authority to take title of property, sell and or lease, transfer property, purchase annuity, enter into a contract for your life care education, collect, hold, attain assets, participate in business operations, pay taxes, loan out money. But they are limited in what the court will allow them to do. They are not allowed to make gifts, convey or disclaim contingent interest in property, create a trust, change beneficiaries, or make or amend or revoke a person's will without seeking court approval. If you're going to do this yourself, there are some resources to look at and think about. One is the Colorado Revised Statutes, 1514-101 through 122 has general provisions on probate, and then 301 to 318 is about guardianship of adults, and then 401 through 433 is about conservatorships for adults. There's also the Colorado Courts website, in which they have instructions, forms, and manuals on how to be a guardian and or conservator. And then the Colorado Bar Association, a lot of times they have documents about how to do these, and they can recommend attorneys if you need or want one. And or you can contact me. And here's my email and my phone number if you have any questions. Thank you.
I'm watching for online questions, but any other questions in the group?
When do you file for guardianship when your child turns 18, or how do you know when, especially pertaining to kids with Down syndrome? How do we know when to file for guardianship?
If he or she does not, if you believe they do not have capacity, probably best to file at 18, just to be safe, because I mean, a lot of times you deal with the same doctors every day, and a lot of times they let it slide, even though the child may be 20, they still talk to you about the needs and the care and stuff. But there's going to come to a day that that's not going to happen, where a hospital or a doctor says, you're not the legal guardian. So I would say definitely at 18 is when you would want to file.
So you wouldn't recommend doing it in advance while he's still a minor?
That's a possibility. I mean, that is a possibility as well.
In this situation, he's very young.
Right.
You know, I don't know how long to wait to get the ball rolling, because obviously this doesn't happen overnight.
I mean, 6 to 8 weeks is typical. So, yeah, I would say 17 is a good time. 16, 17, talk
So
to.
you can't wait that long.
Oh, yeah. You can talk to an attorney about it then. Because, I mean, you still have guardian, you're still his legal guardian until he or she turns 18.
Right.
And so you can wait until then, yes.
Does Does a social worker then come to visit you and your ward at the time of the application?
Usually it's the court visitor will come, and they'll provide, they're the eyes and ears for the court. And so they'll ask questions, interview the respondent to the best of his or her abilities, interview you guys, look at the living arrangements, speak with a physician as possibly, maybe even some of the interested persons, and then go back to the court with a file and a report saying, yes, a guardianship should be appointed, and here's some limitations probably.
So more than one people then is contacted, I mean, do they contact the teachers or people the guardian knows, or like you said, the physician?
It's possible they'll do that. I mean, it just depends on each situation is different. Usually they at least interview the respondent, petitioner, proposed guardian, physician. They may go farther, depends on the court visitor and the situation.
Does the guardian include the duties and powers of the conservator, or those two?
Oh, I'm sorry.
Completely separate?
Those are separate.
Okay.
A guardian can care for a ward's certain assets and income, but if the ward or the respondent has substantial assets, business operations, things like that, then it's best to also get conservatorship also over the person, the respondent.
So generally, people only do that if they
Right. If all the respondent receives is SSI, just guardianship is fine.
So if something should happen to the parents of the child, and it's when they're young, and I know you have to set the will and things like that, but how do you start the process? Can you start the process of guardianship, just setting that in place so it's, I guess, a smoother transition for the child and the people that are seeking guardianship?
Typically in the will, you can say who you want to be your guardian.
Right.
You can put that in there, but it's the court makes the decision.
But your will acts as like the petitioner.
Yeah, correct. I mean, yes, correct. Whoever your personal representative, there will be provision in the will, say guardianship for minor child.
Okay.
And you can also, there's also another document that you can fill out along with the will, that sort of is an extra boost to that, say this is who I want to be the guardian. But the court has ultimate responsibility and ultimate say of who is that guardian. Typically, they go with.
But that document would be added. It's not said.
Yeah, I'm blanking on the name of the document right now.
Some of the court would really like to see it making that decision. I guess it helps drive that along probably.
Correct. I mean, a lot of times they'll take into account the wishes of the parents, especially with special needs child, if that's somebody who would care for, who is already in the child's life, who would care for it, something like that.
Okay.
So would that document be on the Bar Association website?
The will?
No, the
Yeah.
form that you mentioned. You did have a name for it.
That I don't know if it's on the CBA website or not. I can check on that.
But to further that question, so if we've got guardianship for a minor, that's great. Most of us, once we have a will, do.
Mhm.
But what I haven't thought about is what happens when our son turns 18 and who needs to be his guardianship. So who needs to take over that guardianship or continue that guardianship? What do we do to bridge that gap?
So you have guardianship over a minor right now, obviously. Are you talking about when he turns 18 and you guys are still alive?
No,
Okay.
if he turns 18 and say, we've both passed away.
Okay.
So obviously we've appointed somebody to be his guardian from now until he's 18. But then when he turns 18, what happens if he needs a guardian?
Well, whoever you appointed, ideally he or she would then contact the court and apply for guardianship
Okay.
for the adult child. Doesn't always happen though, because I just received a phone call today where she called. Her son's 28, has CP, and she needed a guardianship because she hadn't gotten one over the past 10 years because nobody had asked for one. And so, whoever is your proposed guardian in your will, you will most likely would want to put in there. And when my son turns 18, my proposed guardian should apply for full guardianship over the adult child.
Okay.
So inform the proposed guardian to follow up at age 18?
Yes.
to continue.
Yes. Yes. Especially if you have a child with special needs. When you're doing your estate planning, it's important to have instructions for whoever may become the guardian of the child. Even if your child, you guys live a long, happy life, and your child isn't 35, 40, when you pass, it's important to have instructions there set in place so when that happens, the personal representative, the proposed guardian, they know what to do, where to go, where his meds are, his best friends, what activities he plans to do, he likes to do, where he's going to live. Have that in place. So, and have the proposed guardian know where to find this, so that you don't miss a beat. It's much seamless and much not nearly as harsh for your son. Yeah.
So similar to the way that a parent can specify who the guardian they prefer to be in the will, looking down the road, hopefully willing long down the road. If I was the guardian, say, and something happened to me, he's still alive, do I need to have that spelled out in my will as the guardian, in the same way a parent spelled out that, I would become the guardian? It could be a sibling, say?
That's a good question, actually.
So that it's, obviously the parent can do it
Yeah,
for the guardian,
yeah,
but then
yeah.
if something happens to that guardian, I know you could use 10 times, right?
Yeah.
But just assume once is probably reasonable to a
Right.
sibling, because, it's probably gonna outlive me.
Right. That's actually a good question. I would say yes, but I'm not quite sure, and I can find that out. But if he or she has legal guardianship over somebody, then that should be spelled out in a will. But I'll make sure that yeah.
I just wanna make sure that transition is
Yeah.
handled down the road too.
Yeah.
Right.
Any other questions? I'll check online.
Oh, one quick one.
Yeah.
Assuming both parents are still alive, do both parents need to consent to the selection of the proposed guardian?
Typically, yes. That would make it nice for the,
Right.
because if not, then that would,
Legal problem.
yeah. It makes it much nicer if both consent, yes.
Another question, so with guardianship, say I'm the primary care for my son, and my parents, second, my brother would be probably following that.
Mhm.
If his dad is not capable, or I don't believe is capable of taking care of the child after, and I know it might be a big legal mess, but how do I prepare, because I would propose guardianship separate of their father. Because would I need more supportive information and documentation just now to keep that up in case something should happen to me later on? If he and I don't agree on a guardianship, when he's alive and wants one, he doesn't have the capacity to do it.
Court will look at the parent, if typically there's an order that a court will look at and spelled out in the statute of who has priority. I can find that for you exactly what order is. I didn't put it in here. And the court will normally follow that order. In terms of where you have spelled out guardian versus the children's father, that would probably just depend on the situation. That, I'm not sure about that.
The court would take that in case by case.
Probably.
Okay,
Okay,
unless you have other questions, thank you so much, Chris.
thank you.
We will make this, we've taped this, so we'll make this available if you wanna go back and review it. And for those online, if they need a copy of the handouts, please give us a call and we'll get you that as well. Thank you.
Thank you.
Thank you. Nice handout.